Hey, everybody. Welcome. Happy True Crime Wednesday. If you are new and just joining us for the first time, my name is Lori Hellis, and I am a retired criminal attorney, and I have written a book about the Vallow Daybell case, and you can see it in the background. So welcome, everybody. Great to see you all. Great to see folks in the chat already. Welcome, welcome. And hello to all you folks who've been waiting. We have a lot to talk about. We did chat on a surprise live on Sunday, so we're caught up a little bit, but there's still a lot to talk about. We need to catch up on a few things having to do with the Alec Baldwin Hannah Gutierrez Reed case. There's a couple of developments in the YSL Young Thug case that are interesting. There have been some projections of a court date for Rex Heuermann in the Long Island serial killer case. And we have a number of cases upcoming late this summer or early in the fall. And we also have some questions that we need to talk about on the Karen Reed case. So welcome, everybody. And I think we'll just dive in. Before I do that, though, please like and subscribe. It helps us with the YouTube algorithm, so please do that. Pop out for a minute, hit the thumbs up button, hit the subscribe button if you are not already a subscriber. In addition to writing a book, I also periodically write a true crime newsletter. The newsletter began originally as a way to talk about to deep dive into some of the legal issues on the Vallow Daybell case. Now that those cases are, for the most part, resolved, Lori still has charges pending in Arizona. We'll talk about those a little bit later. But now that that is resolved, I do have the opportunity for those of you who really like a deep dive into the legal issues on a case. That's where you can find them in my newsletter. And now that I am not writing on the book every day, I will have a little bit, and my move from Idaho to Oregon is almost complete. I'll have a little more time to devote to some of those deep dives into legal issues. I do have quite a few of those newsletters in the archive at thelorivallostory.com. And you can take a look at what we already have. If you have questions or legal issues that you would like me to tackle in depth, please drop a comment or email me and let me know that you've got something you'd like me to really dig into and do some in-depth analysis on. So I do want to give everybody an update on the book. The book has gone to the publisher. I'm super excited for the 106 people who signed up for the launch team and agreed to receive a digital copy of the book in return for reading it early, reading the advanced copy, and then posting a review. Those PDFs have gone out. If you have not gotten yours, check your spam file, because I know they've gone out. People have received them. And I've already been getting people saying, I won't be doing anything for the next couple of days, but reading your book. So I want to say thanks to all of those folks who agreed to join the launch team and are already talking about their posted reviews. Reviews are incredibly important, especially on Amazon, because it takes 60 reviews before Amazon will, oh good, I just saw somebody in the chat said they got theirs, their digital copy. Reviews are super important because Amazon will not begin pushing the book out as a suggested title until there are 60 reviews. So the more reviews we get, the better, because then Amazon will begin, the book will pop up in the recommended for you section of a person's page if they have ordered or searched for true crime titles in the past. And that it's just a great way for people to know the book is out there and that it's available. So please, 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 if you have gotten an advance copy, please take 10 minutes and write that review, because even if it's a single sentence or just stars, it makes a difference when it comes to Amazon's algorithm. There are certainly other sites as well. Goodreads is also important, as is Barnes and Noble. So posting reviews, if you write a review for Amazon, copy it, paste it in, and repost it to the other recommended sites. If you got your copy, you also got an email that had links to all of the review sites. And since the copies have gone out, I've gotten several people asking me if and when the book will be available internationally, particularly in the UK, Australia, and New Zealand. Yes, the book will be available. My publisher assures me that it will be available internationally. It's sometimes, because of the distribution chain, it sometimes lags the US release, but it should be available. I checked the Amazon UK site, and it is available for pre-order there. So I expect that it will be released right about the same time as the book hits the shelves here in the US. The Audible version will be available at the same time that the book is released to bookstores. So September 24th, you should be able to get your audio version as well. My daughter and I reviewed and picked the narrator, and I noticed, Jen noticed actually, that they are now publicizing on their site that the book is going to be upcoming and produced by that company. They're an independent producer who contracts with my publisher to publish the audio version of the book. So it's all coming together. Thanks for all of you who have pre-ordered and all of you who have agreed to be early readers. I appreciate your interest and your devotion to doing it and your commitment. So let's start out talking about Baldwin and Hannah Gutierrez Reid. I saw a lot of questions asking about whether or not Hannah could get a new trial. And her defense attorneys have already filed a motion asking that she receive a new trial because of the extreme misconduct of the prosecution. And the fact that they, at a minimum, failed to provide necessary discovery, and at the worst interpretation may be that they actually buried it. They buried that information. So for those who may not have heard exactly what happened, there was and I'm going to try and do this in as simple a way as possible, because that case has, like most cases, has so many moving parts. But there was a man, his name is Seth, of course, just escaped me, Seth Thomas. He was the person who owned the prop company that provided all of the props for the site for the movie. he provided the guns, including the real guns. He provided some prop guns and some real guns. He also was responsible for providing the blanks and the dummy rounds. Now, dummy rounds are bullets that look like functional bullets, but have no powder in them. And the reason they make those is for camera close-ups. When there's a close-up of the gun or there's a close-up of a bandolier, you want it to look like the bullets are real. But they are in place of where the gunpowder would be is a BB. And when you pick up that bullet and shake it, it rattles like a paint can. And so this person was responsible from PDQ Props, was responsible for providing the guns and the dummies as well as blanks. Now, blanks are created without a projectile, and so they make a flash and a bang, but they don't shoot anything. In general, sometimes they have wadding in them that can come out of the gun, but doesn't travel very far. So in addition to the dummy rounds and the blanks, this person was also involved, along with Hannah Gutierrez. I don't know why I'm having so hard a time with that. Hannah Gutierrez Reed's stepfather. They had been tasked with putting on what they call a cowboy camp, which is an opportunity for actors to learn how to handle the guns and to live fire the guns with real bullets at a target range where they can get a feel for the guns, get a feel for what it feels like when you actually fire a bullet, all of those things, the recoil, all of those things. So they learn how to handle the guns, learn what they feel like when you actually shoot them. And that is all part of their learning their characters and learning how to interact with the guns. So that happened both on Rust and on the set of 1883, which was Kevin Costner's spinoff of Yellowstone. And during both of those, prior to both of those starting filming, I think his name is odd. It's like Tail or Tane Reed, the stepfather, and the PDQ prop guy put on these cowboy camps. And that was done in advance of filming. So, but the PDQ prop guy and Hannah Reed's father were responsible for the live rounds that were going back and forth to the cowboy camp. Now, ideally, there should never be live rounds at the prop house. And that probably was the first mistake, was that there were live rounds brought back from the cowboy camp to the prop house. That probably was the first mistake. So there was a third person who was involved in putting on these cowboy camps, and he was responsible for transporting some of the live ammunition. So he got in contact with the prosecution and said, I have these live rounds. This was during Hannah's trial, just this year. And he said, I have these live rounds, and they came from this cowboy camp, and they came through the prop guy, and I think they're the same rounds as the live rounds that got fired during that killed Helena Hutchins. And so he was in Arizona, the case was in New Mexico. The prosecutor said, before I have somebody come and get them, take pictures and send them to me. So he sent them pictures of the rounds. The prosecutor said, these rounds don't look anything like the live rounds that were fired on the set. It later came to pass that So that happened before Hannah's trial started. After Hannah's trial was going on, that guy actually went to the courthouse in New Mexico and said, I have these bullets, a handful of them, and I think they're related to this trial. And the sheriff, the prosecutor, and the lead investigator were right in the middle of the trial and said, tell him he'll have to wait. Well, he left and he went to the sheriff's office instead and turned them in. Then the investigating officer and the prosecutor and a couple of other police officers all discussed it, and the crime scene investigator who was responsible for checking those things into evidence was told to book it in under a separate case number, not linked to the Hannah Gutierrez Reed and Alec Baldwin cases. So there was never any way to flag it. Now, it's not entirely unusual for there to be separate case numbers in a case where there might be more than one co-defendant, or there might be more than one charge going on. But there's always a way to link that separate number to the associated case. That did not happen. And so it just got buried. When the defense then said, we know those are out there because they talked to the guy who turned them in, called them, and they said, we know these bullets are out there, but we've never seen them. So then they have a evidentiary hearing outside the presence of the jury, and the judge says, I want to see the report. I want to see the bullets. So they bring in the report. They bring the police report about receiving the bullets. They bring in the bullets themselves. The crime scene investigator sits them all out on a table. The judge puts gloves on and looks at them, which is highly irregular. And Carrie Morrissey, who is the lead prosecutor, the defense says, we've never seen this report. We've never seen these bullets before. Carrie Morrissey says, I haven't, this is the first time I've seen them either. So she misled the court into believing that she did not know that they were there. She did know, and in fact, she endorsed them being filed in under a different case number. Now, whether Carrie Morrissey, who was a special prosecutor, was not didn't routinely prosecute cases, didn't understand what that meant from law enforcement, or whether she did it purposefully, I don't think we'll ever know. But the judge said this is clearly information and evidence that should have been disclosed, and should have been disclosed so that the defense could use it either in opening statements or in the way they questioned the crime scene investigators, the lead investigator, and they weren't turned over. The judge felt that it was an egregious enough oversight or purposeful misconduct that because the jury had already been sworn in and jeopardy attaches, she had no other choice but to dismiss the case and to order it dismissed with prejudice, meaning that it could not be refiled. So because of double jeopardy. Once the jury was sworn in, a dismissal like that could only be done with prejudice. So the judge dismissed the case. It could not be rebrought against Alec Baldwin. Now, it seems to me that Hannah's case, her attorneys have a little bit different problem, because they knew that they existed, and they in fact didn't want them because they felt like they further incriminated Hannah. Because when the bullets came in, they looked like the dummy rounds. They didn't resemble the live rounds that were found in the gun and the live rounds that killed Halyna Hutchins. They didn't resemble those, but what they did look like was they were dead ringers for the dummy rounds, and that is pretty dangerous. So I don't know that it's helpful, that the actual evidence is helpful for Hannah, but the fact that there was prosecutorial misconduct may very well get her a new trial. Her defense team is asking that the court also dismiss her trial because it was the same prosecutor that prosecuted Alec Baldwin. I think there are some different nuances to it, and I don't expect that the judge is going to outright dismiss her case with prejudice. I think what we may see is actually a new trial for her. I saw a question about the civil ramifications of this as well. And I want to point out, we talked about it last time, that civil and criminal have very different standards of proof. So a criminal case has to be proved beyond a reasonable doubt. That's like 98, 99% certain. A civil case, on the other hand, the evidence only has to weigh more likely than not, meaning 51% sure. So I think that it is possible that that there may still be criminal, that there may still be civil consequences for everyone else, but Alec Baldwin has settled his case with Halyna Hutchins' husband, Matt. So what is sort of interesting is that he settled for an undisclosed amount of money with Alec Baldwin. Part of that, and Matt Hutchins is also a lawyer. Part of that settlement also involved him becoming an executive producer on Rust, which seems a little counterintuitive. If you've sued Alec Baldwin and you hold him responsible, why would you want to go to work on his movie? From what I can tell, there are two reasons why he might want to go to work on Alec Baldwin's movie. The first one is because I think he wants to protect Halyna's the work that she did on the movie, that he feels like he wants the movie to be finished because it's her last film. The other reason may be because he has a financial interest in making sure that the movie gets finished and gets sold. So I think these kind of things make strange bedfellows sometimes, but it makes a certain amount of sense that that Matt Hutchins wants to complete the movie because he feels like he has an interest in assuring that Halyna's work is preserved. There were also some comments about Carrie Morrissey, the special prosecutor. And I did express, just as another lawyer, that I did in some way feel sorry for her. I realize that this is very likely a situation of her own creation, But I couldn't help but still just feel a little pang of, oh, sister, I cannot imagine what you are going through right now. These sorts of things, especially in a high visibility case like a famous actor, can be career killers. And I know that she has her own practice, but nonetheless, if the clients aren't beating down your door, then it doesn't matter who you work for. It's going to ruin your career. So I do still have a small modicum of sympathy for her. But I cannot argue that the way that she presented herself in court was incredibly unlikable. I noticed people pointing out that she behaved very differently when she was only arguing to the judge versus being in front of the jury. And but that she often was pretty condescending and belittling, and it felt like it was over the top and unnecessary. So I can't disagree with that part. So moving on to YSL and the Young Thug trial. This trial is interesting for quite a few different reasons. The first being that it is a very large co-defendant case. There are a lot of co-defendants in this case, upwards of 20, I think. And they are all people who were involved with this gang, this record label turned gang, or gang turned record label, whichever you like. And the prosecution was unable to get them on a lot of the underlying state court sorts of offenses. And so they went after them under RICO. And RICO is the organized crime statute. So it's had a lot of moving parts because of that, but it's also been very interesting because of the conflict between the prosecution and the defense attorneys, the conflict between the defense and the judge. And the trial has been going on for more than a year. And the jury has been seated for something like 8 months. And it really has just dragged on in ways that are hard to understand. The other interesting piece of this is that this is in the same jurisdiction and the same office prosecuting the Georgia prosecution of Donald Trump for election interference. And so this same elected DA, Fani Willis, is coming under fire in both cases. Now, you may remember this is the case where Judge Glanville was presiding over the case. He held what amounted to an ex parte meeting with the prosecution and the prosecution's star witness about whether or not that witness was going to testify or whether or not that person was going to invoke their Fifth Amendment right not to incriminate themselves. However, he had been granted immunity, and once you're granted immunity, you can't plead the Fifth. So the judge kept saying, if you plead the Fifth, I'm going to put you in jail. And they had a meeting where the defense wasn't present, but the judge, the prosecution, some of the law enforcement officers were all meeting and trying to explain to this guy why he needed to testify and why he was going to go to jail if he didn't. He had gotten on the stand. He had promptly, when they asked him how old he was, said, I plead the Fifth, and the judge said, take him into custody. He sat in jail over the weekend, and on Monday they brought him back in. That's when the ex parte meeting happened, Well, somebody told the defense that the judge had been meeting privately with the prosecution and their witness. And the defense said, why weren't we invited? That's not appropriate. And then what happened was, instead of the judge saying it was appropriate, or and here's the reasons, or whatever, responding to the concern, he immediately went on the defense and said, how did you find out about it? This is a private protected meeting. You shouldn't have had access to it, blah, blah, blah. Well, the attorney declined to tell the judge who had told him about the meeting. And as a result, the judge held the attorney, his name is Brian Steele, in contempt of court and sent him to jail. And the judge later backed off a little bit and said, I'm going to let you work all week, and then you can go to jail on the weekends to serve your 20-day sentence. So you need to serve 2 days a month for the next 10 months to get your 20 days in. In the meantime, a group of defense attorneys that they call the strike force, who are put together for just these sorts of situations, filed motions with the Supreme Court. The Supreme Court granted a supersedious bond, which essentially is a restraining order, a temporary restraining order on a temporary moratorium on the imposition of the sentence. And so he is still appearing in court. But then there was all this furor about Brian Steele, as well as the attorneys for the other co-defendants, filed motions to dismiss the case, motions for mistrials, and motions to recuse Judge Glanville. Judge Glanville then resisted those motions, said he wasn't going to allow them to be heard, even though Georgia law says that when a motion to recuse is filed, everything else on the case has to stop until a decision is made on that motion to recuse. The next thing that has to happen is that has to be referred to a different judge. The judge being asked to recuse themselves is not the one who can make the decision. So the Judge Glanville had violated all of those parts of Georgia law. After a lot of public pressure, he then sort of backed off, released at least a partial transcript of the ex parte meeting, because there was a court reporter in who recorded the meeting, and agreed to have a different judge decide the recusal motion. That judge ordered Judge Glanville recused, and she appointed a new judge, Judge Ingram, to pick up the YSL case. Now, how a judge does that, I don't know. I mean, this case has been going on for 8 months, and they've heard all this testimony, and now this judge is having to pick up in the middle of the case. But nonetheless, Judge Ingram just either yesterday or this morning, I think it was this morning, filed her own order recusing herself because of a potential conflict. So we don't know whether that Fulton County is actually going to be able to find a judge that doesn't have a conflict. Now, remember, these are the co-defendants in this case are all allegedly gang members, and they all have lengthy criminal histories. So it's very unlikely that they're going to find a judge who's never met some of these co-defendants. They've all been in front of the judges in Fulton County on numerous occasions. So that one will be interesting to see how that pans out. I suspect that the defense is going to be filing change of venue motions based on the fact that they can't get a judge that isn't conflicted out in Fulton County. And I think any judge worth their salt is going to do their best to try and find a conflict so they don't have to take over this clinker of a case. So So yet to be determined, because as long as they're in this flux of trying to find a different judge, the case can't go on. So it's on hold, and no one knows how long it's going to be on hold before they finally find a judge. So there's some rumblings going on that moving on to Rex Heuermann, the Long Island, the alleged Long Island serial killer. He has now been charged with 6 murders of bodies that have been recovered along the stretch of beach near his home. And they're continuing to investigate. There are numerous other bodies that they are investigating and attempting to link to Heuermann as well. Probably the most interesting thing that came out was some information that came out of his one of his computers or other devices. It was a document that he had attempted to delete, but was still in the computer system somehow. And when it was recovered, it was very clear that it was a to-do list and a how-to list for committing serial murders involving sadomasochism and torture. And so this casts a whole different light. Until that information was recovered and made available to the defense and to the public, Rex Heuermann was taking the position that he was not guilty, that they had the wrong guy. Finding a roadmap on how he intended to commit the crimes that he committed casts that all in a really different light. As a defense attorney, sometimes the smoking gun shows up and there's really nothing to do but to explain to your client that they need to minimize their consequences, and perhaps the only thing that he can do at this point is life without parole. So I think that as the evidence piles up against him, I think we may see a plea. It would not surprise me at all for there to be a plea, and part of the plea agreement be to be transparent about all the other victims, because I don't think that the victims that he's been charged with span clear back into the mid-90s, and it would be unrealistic to think that there weren't other victims out there over those periods of time, that over all of those years there were only 6 victims. That's just not realistic, knowing what we know about serial killer behavior. So I don't think that they have found anywhere near all the victims, and it would make a certain amount of sense if they've got him dead to rights and the best they're going to do is life in prison without parole, that it makes a certain amount of sense to get him to reveal the other victims and the connections to the other victims. Now, I want to say there is an attorney. He is a civil attorney, and he represents some of the victims' families, some of the families of the 6 charged victims. And he is a sort of a flamboyant guy. He always wears unusual clothes, sometimes wears a hat, older guy. He recently came out and released some information about Rex Heuermann's daughter, Victoria. It had to do with her social media, with her Tumblr blog account. And I think that it was very irresponsible on his behalf. First of all, he was pointing out that for the most part, although I understand she is an artist, for the most part, the things that were on her Tumblr page were reposts of other artists. And there were some very graphic artistic renderings. But there is absolutely no indication that any member of Heuermann's family was involved in any way. And law enforcement has gone out of their way to say Asa Ellerup, his wife, his daughter Victoria, Asa's son, who is developmentally disabled, none of them, there is no indication that they were involved. It is true that Asa's hair was found on a couple of the victims, but we have talked at length about how hair is one of the easiest things to transfer from one person to another, whether it's your hair or your dog's hair or somebody else the hair of somebody else that lives in your house. One of the easiest things in the world is to transfer hair. Hair sheds. We shed hair every day. Some of us more than others. And so it is, up until recently, the only way that law enforcement could test hair genetically was if there was tissue attached at the root of the hair. And they actually were not testing the hair shaft. They were testing the cells that were collected at the root of the hair. However, there is new technology that's been developed where they can actually draw the DNA and map the genome of the person who deposited the hair, which is why they were able to identify one of those hairs as Asa Ellerup's. That does not mean that she's in any way involved. She shared a house. It's just like saying that Lori Vallow's hair was found in the tape that duct taped JJ, so she must have put the duct tape on him. That's just a bridge too far, because we know that Lori Vallow shared a bedroom and often a bed with her son. He was a difficult kid to get to sleep. He often had night terrors. And there were many, many nights when he slept in her bed. So it is unfair to the victims to connect them up in a way that law enforcement has been very clear they are not connected. And I think that it really shows a lot of tone deafness on the part of this attorney, because he could very well be putting Rex Heuermann's daughter's life at risk. There are a lot of people out there who have taken this case very seriously. I don't want to get political, but there are a lot of people out there who have taken the assassination attempt on Donald Trump very, very seriously. And there are a lot of people out there who may very well do something violent and dangerous as a result. And that's not limited to just Donald Trump. It's in every high visibility case. Why do you think Karen Reed had a security? Hi, KJ Hellis. Nice to see you. I haven't talked to her in a couple of days, so it's nice to see her here. But why do you think Karen Reed had a security guard going in and out of the courtroom? I mean, there were protesters and supporters and all sorts of people in front of the courtroom every day. And that's what happens in these high visibility, highly publicized cases. So I think it was very irresponsible of him to put Victoria Heuermann in that position. Because we have no reason to believe that she was involved in any way. Now, speaking of Karen Reed, let's talk about the Reed case. So as you know, after 8 or 10 weeks of evidence, the jury was unable to reach a unanimous decision, and the judge declared a mistrial. Early in the case, when the court was talking about jury instructions and about the verdict form that always goes to the jury with the jury instructions, Karen Reed's attorneys raised the issue that they believed that the verdict form was confusing. The verdict form that they used was not the standard verdict form. Now, in every state, a group of lawyers and judges get together and they formulate the uniform jury instructions. Now, judges aren't required to give those instructions, but they are the ones that are most readily recognized as the acceptable jury instructions. Sometimes lawyers ask that they change some wording in a jury instruction. Sometimes the judge will do it on their own motion if they feel like the jury instruction isn't accurate for that particular case. So what they also do, in addition to uniform jury instructions, is they also have a uniform verdict form. And that form explains how to fill it out, when you find for a lesser included offense, when you find for, and it lays it all out. Judge Cannoni, what generally happens is the prosecution proposes the verdict form and the defense then raises any concerns that they have to the verdict form. The prosecution presented the verdict form to Judge Cannoni. Now, the defense did not say, this isn't the right verdict form. We ought to be using the uniform verdict form, the one that everybody agrees is right. They didn't do that. Instead, they raised the issue that they felt like the instructions to the jury, that the verdict form was confusing. And Judge Cannoni said she was going to clarify the instructions. She did not give a clear instruction on what to do if they reached a verdict on one count and were hung on another. And so that instruction was never given. So the jury came back and said, we're hopelessly deadlocked. And the judge declared a mistrial. Following that, when the defense began talking to the media, when people began talking to the media, the jury came to the conclusion that they had been mistaken and that they could have said she was not guilty on the two charges where they did reach a unanimous decision. However, they didn't. They thought that they had to be unanimous on all the counts. And so they didn't communicate that to the judge. The judge didn't ask. And more importantly, the defense did not ask to have the jury polled. They did not ask the court to ask the jury those questions. So then these jurors start coming forward and saying, wait a minute, we don't think it's fair that she has to be retried on two of the counts because we only deadlocked on one count. We found not guilty on the murder, on the second degree murder charge, and on the DUI with causing injury. The count that they deadlocked on was the involuntary homicide count. So the defense has filed a lengthy motion saying, wait a minute, we want the court to either declare that she is not guilty on those two charges or dismiss them with prejudice, as happened in Alec Baldwin. Now, in this case, we're not talking about any kind of prosecutorial misconduct. So declaring a dismissal and not allowing those charges to be refiled doesn't have a lot of legal basis for doing it. There's not a lot of legal support for it. So it really comes down to being up to the prosecutor at this point, whether or not they are going to retry Karen Read on all of the charges or not, or whether they are only going to retry her on the involuntary manslaughter charge. The prosecution can decide. Now, initially, the prosecution said we fully intend to retry the case, but that was before these jurors came out. So the prosecution may use that as a convenient way to say, well, hold on, maybe we won't try her on all of the charges. That remains to be seen. The prosecution at this point, the Commonwealth is pushing back and saying, we're going to retry her. And here is the dilemma. The dilemma is that the jury has been released. Now, while a jury is in deliberation, they are all together in one place. They go through all of the evidence. They communicate with the judge, and they are, for all intents and purposes, sequestered. So they're told, don't look up anything, don't watch the case, and they're kept separate while they deliberate. Once they're released and that deliberation is done, they're free to watch anything they want. They can watch every second of the trial on a replay. They can watch every second of all of the pretrial motions that they weren't privy to. They can dig deep into the case. And what that means is now they are tainted by all of that post-trial information. So it would be very difficult for a judge to call the jury back and say, tell me what your decision was on counts 1 and 3, because I think the prosecution would jump up and down and say, wait a minute, these people could be basing what they're saying they decided during their deliberation on things that they've learned since the trial. So I do not think that they get Judge Cannoni or any judge to call the jury back in and talk to them about it. This is very different than Murdoch. Okay. On Murdoch, the issue, the reason why they called the jurors back in and questioned them was because there was an outside influence. There was Courthouse Becky, who was the clerk of the court. And so that was a totally different situation because there was exterior pressure. In this case, this was a jury who just said, we have several people within, or a person, or however many people within this pool who have very strongly held beliefs about this case, and they're not going to change their minds. And so we're never going to reach consensus. We're never going to reach unanimity on the case. So very different from Murdoch. So the judge doesn't really have, there's no mechanism for the judge to say, I'll let you come back in and do your verdict form over, because if you'd done it right the first time, it would have been a not guilty on counts 1 and 3. I don't think that holds up legally. I don't think there's a real legal basis in the law for it. And I think what we're stuck with is the Commonwealth is going to have to decide what, if any, of the charges they're going to retry Karen Read on. If they were smart, they would simply say, we're not going to retry her. However, remember that that district attorney, Commonwealth prosecutors are, for the most part, elected officials, and they are political animals. And so an elected prosecutor who wants to get reelected is going to go out of their way to look tough on crime. They're not going to want to look soft on crime. I think this is probably one of the big issues that is hovering over Fani Willis in Georgia right now, because she is elected and she is a political animal, and she has got an interest in seeing herself reelected. And reelection means giving at least the outward impression that you are tough on crime. So there are a couple of other really interesting developments coming out of Reed. We've talked at length about the issues of corruption and bias within the law enforcement community in Boston, in suburban Boston, in Canton, and in the state police. So Trooper Proctor, Michael Proctor, who was the state police officer that was in charge of the case, he has also been the lead law enforcement investigator on a couple of other high visibility cases. Specifically, he is also the lead investigator in the Brian Walsh case. Now, Brian Walsh is the fellow, he is, his wife was a realtor. He was involved in shady art trading and dealing, and she was a realtor. She supposedly got an Uber to the airport to go she's either in Miami and went to Tallahassee or back and forth. I can't remember, but she was flying out to do some work in Washington, D.C., where she also had business dealings. And she never showed up. Never showed up in Washington, D.C., never showed up anywhere. The law enforcement has every reason to believe that she was murdered and her body dismembered and distributed in dumpsters all over town. Her body has never been found, but Brian Walsh was found in possession of tools and other things that were positive for her blood. It's presumed at this point that she is dead. Kind of like the Troconis case, where the body was never recovered. So that case, Michael Proctor is also the investigating officer on that case. Now, he has been put on leave without pay, which is a pretty serious penalty when it comes to law enforcement, and they are going through the process of removing him. Remember, law enforcement, they are state agencies, and in Proctor's case, the law enforcement is the state police. They're all unionized, so they have to go through a very set process, a set of steps that are very clear before someone can be terminated for cause. But putting him on leave without pay is a pretty serious step. You don't see that unless there is substantial information that he is going to be terminated. So that is coming up. That sort of leaves as an unanswered question how they re-prosecute or they retry Karen Reed, how they go forward with prosecution of Brian Walsh. And those are some unanswered questions. On top of that, there is a case of Sarah Birchmore. She was a young explorer scout who was an explorer scout for one of the law enforcement agencies in the neighboring communities. And Canton Police Department was assigned to investigate her death. She was found, she began a relationship with one of the police officers where she was an explorer scout somewhere around age 15. She was in her early 20s when she became pregnant and had had relationships with at least 3 of the officers on that police department. It's in the same community where Karen Reed's parents were living and where her car was impounded. I think Dillon is the name of the town, but I could be wrong. And Canton Police was appointed to investigate that case because that community couldn't investigate it because they were implicated. Initially, her death was ruled a suicide, but has since been reopened and is now being classified as a homicide. So we know that there is some evidence of foul play involved in her death. And it just continues, that vortex, that swirl keeps swirling around the Boston and suburban Boston law enforcement agencies, and going all the way out to the state police. So I think it definitely, those cases bear watching. I think we are going to see Michael Proctor given the heave-ho, and I think we're going to see some serious damage control being done in those law enforcement agencies. Now, does that mean they're going to clear out and clean out the corruption? I don't know. I think there's at least a reasonable chance that they're going to sweep it under the rug and go on doing business as usual. I think that is a reasonable conclusion that one could draw. Unless you're getting somebody in there who is an outsider and a reformer, because the corruption in those organizations goes very deep. So let's talk a little bit, before we take questions, about what to expect coming up later this summer and fall. The most recent one, the one that's coming up the soonest, I'll spit it out here in a minute. I'm telling you, I'm still tired of unpacking boxes and lifting that barge and toting that bale. So my brain gets a little tired by this time of night. But the one that's coming up the soonest is James Craig. He is the dentist who was accused of poisoning his wife. And that trial begins August 8th. Corey Richins is the next thing coming up, and that is a preliminary hearing. Believe it or not, we have still not gotten to a preliminary hearing in Corey Richins' case. Now, you'll recall that there are two ways that a case is confirmed to have probable cause. One is it's presented to a grand jury, and the other is that there is a preliminary hearing held, and the judge finds that there is sufficient evidence to bind the person over for trial. So in the Richins case, and different states prefer different modes. In Idaho, when we were dealing with the Vallow Daybell case, Chad Daybell had a preliminary hearing on the first round of charges, those charges of destroying and hiding evidence. When the time came for the district attorney, the prosecutor, to present the murder charges, they were presented to a grand jury. Idaho typically favors preliminary hearings, as does Utah, which is where Corey Richins is. She's in Utah. So it really is up to the prosecution to decide which way to go. Now, in the Vallow Daybell case, they decided there were a couple of factors that played into them not charging right away. They decided that they wanted to keep the evidence confidential, and everything that is presented in grand jury is secret. And so they waited because of COVID. They had trouble. The court had suspended all the grand juries. So it wasn't until COVID calmed down and they were able to convene a grand jury that they finally brought those charges. Similarly, we've seen what's been going on with Corey Richin. There have been a lot of pretrial motions, evidentiary motions, accusations of witness tampering, a lot of other pieces and moving parts. And so far, Corey Richins hadn't gotten to a preliminary hearing. Add to that the fact that her very well-known lawyer, Sky Lazaro, and her team withdrew from Corey's case. It was unclear why, although what I'll say is that what her attorney said was that there was information that had come up in the civil case having to do with the victim's family and his business interests that had created a conflict with Sky Lazaro and her team with the criminal case. It could very well be that she just couldn't pay anymore too, but there appeared to be some sort of conflict of interest that was created by that, by Corey's involvement in that civil case that was presented in court. So either way, she now has a public defender, and her public defender will be presenting the case, and that is coming up August 26th, 27th, and 28th. That is the preliminary hearing. Whether they move to set that over or not, because the public defender is new on the case, I don't know. But that case is getting a little long in the tooth, and I think the judge is going to push to get that one ahead, at least to the preliminary hearing point. So then next we have a couple of things that are happening in October. In October, Brian Walsh, October 2nd, Brian Walsh is having a hearing on a motion hearing. He doesn't have a trial date set yet, but there are motion hearings set for October. And in general, you've seen this. You saw it happen in Reed. You've seen it happen in a couple of other cases. They hold what they call, you saw it in Koberger, they hold what they call an omnibus motion hearing. And what that means is all of the pending motions get decided on that day, and the judge takes them all up. So it appears that is going to be, in October, will be an omnibus hearing on evidentiary matters. Lori Vallow was set for August 1st for her trial to begin. She has not waived her speedy trial rights. Despite that, the judge in the case, over her objection, granted a continuance to the defense in her case, that's the Arizona cases, having to do with the murder of Charles Vallow and the attempted murder of Brandon Boudreaux. The judge moved that to February of 2025 over her objections. And I have not had the opportunity yet to dig into Arizona law to find out why the judge can do that over her objections. So that's something I want to delve into. The Richard Allen Delphi case is scheduled to begin on October 14th. Now that one, there are still pending motions to recuse Judge Gull in that case, and there are still some pretty substantial evidentiary motions pending. One of the things that's going on is that Judge Gull has said there will be no televised, there will be no cameras in the courtroom, and she will not release recordings of the court proceedings like they did in Lori Vallow's case. So we are stuck with hearing what's happening from people who are actually going to be in the courtroom in Delphi, Indiana. One of those people who will be in the courtroom is Bob Motta from Defense Diaries. He is a defense attorney like I am, and he and his wife, Allie, are both criminal defense attorneys. Allie is still practicing. Bob is devoting all of his time to podcasts and YouTube. He has a really interesting podcast, the podcast, which is very nicely produced. Bob Motta's father was the defense attorney who represented John Gacy. And when he died, he left Bob all of the tapes that he taped of all of his interviews with Gacy. And so Bob has done a podcast series along with another fellow who is former law enforcement, talking about whether or not there were more victims of Gacy's that were never discovered, and playing bits and pieces of those Gacy tapes. So super interesting. His links are in our show notes. And if you are interested in Delphi, he's going to be the best resource because he's going to be in the courtroom every day. He and his wife, Allie, practice in Illinois, and he will be commuting over to attend the trial in Indiana. And lastly, we have Brian Koberger, and his trial is now set for June 2nd of 2025. Now, is it going to happen? Don't know. The defense attorney, Ann Taylor, has already said we're going to shoot for that date, but we are not waiving any of our outstanding motions. They still have a motion to change venue out there. There was a big furor about that. That has been resolved, and they are still doing some research to support their change of venue motion. The interviews and the surveying had been done in the jurisdiction in Moscow. What hadn't been done was to compare that to other jurisdictions outside of Moscow. So what they wanted to do was conduct the same surveys, say in Boise, with a much larger population and more diverse population, and do some surveys about what sort of exposure people in Boise had to the case. So, as Ann Taylor said, it doesn't help us to say to the judge, we can't get a fair jury pool in Moscow if we can't also say what the jury pool would look like if we move the trial to Boise. So that's what they're grappling with right now. There are some motion hearings set. I didn't make a note of them, but there are motion hearings coming up. It seems to me the change of venue motion is coming up in August, but I might be wrong, because sometimes it's hard to hold all these dates and names in your head. So if you have a case that you would like us to cover, please drop it in the comments, send me an email, drop it in the YouTube comments, put it in the chat, whatever way you want to communicate with me, but let us know if there's something that you would like me to cover in particular. There are a number of high visibility cases out there. Law and Crime has been covering one recent that started this week, where a man who may or may not be severely schizophrenic murdered his mother. That one's going on. There are a number of other cases going on. Certainly, the ones that I've been through are the ones that seem to have gripped people the most and gripped attention. Oh, Donna Adelson is coming up on the 1st of September, and that is one that I will most assuredly be covering. I have an interest in the idea of grandmothers who toxic grandparenthood, and the idea of grandmothers, and it may be my next book. So I'm very interested in the Adelson case and comparing it and contrasting it with some other cases that are grandmother involved cases, such as Piketon, Ohio, and the case out of Kentucky, Oklahoma and Kentucky, I think. It's of interest to me, and I definitely will be covering it closely. I might even try and attend. I don't know. I'm sort of hoping that I might get there for some portion of Donna Adelson's trial, just to sort of get a flavor for what the court's like in Tallahassee. I know that Joel Waldman from Surviving the Survivor will be covering it very carefully. He has been covering the case really since early days, and has gotten close to Dan Markel's parents and his family. So if you want in-depth coverage, I think as it's happening, I think Joel would be a great resource. So time will tell whether I'll be able to break away and get a few days down there or not. I have some really exciting things coming up. If you happen to be in Central Oregon or in the Portland area, I have book signings coming up. I am trying to arrange a book signing in Boise, and potentially maybe even a signing and a reading in McCall at their gorgeous new library. When I was in McCall, I got a tour of their library, which had only been open about 2 weeks, and it is amazing. It should be the model for what a community library and community space should be. It's incredible. So I'm kind of hoping that I might be able to pull off a signing in Boise, and then maybe a reading and a signing in McCall. So stay tuned, but I will be doing a book signing at Roundabout Books in Bend, Oregon, on 10/10 on October 10th. And I will be doing a book signing and presentation and reading at Powell's Books on September 26th. And if you don't know about Powell's Books is amazing. They are the largest independent bookstore and reseller of books in the country. Their downtown Portland, Oregon location takes up a city block 4 or 5 stories tall. It is an absolutely incredible place to go. They have some satellite stores, and I will be at the one out at Cedar Mill. So I will get more information out for anybody who's interested, and definitely will be providing you with info as time goes on. I'm seeing some questions about possible book signings. So if you have suggestions of bookstores that you would like my publisher to reach out to, please throw them in the chat, throw them in the emails, and let me know, because I would love to do more book signings. So I think we're ready for questions, and I'm going to take a swig here. Hi, Beth. Thanks for your question. Nice to see you in the chat tonight. Didn't the prosecutor agree that the verdict form was confusing? The issue was that there were not guilty checkboxes on the lesser counts. You know, I don't recall the prosecutor actually agreeing that it was confusing. I think that when the judge said, initially the judge said, it's fine. And then she came back, which I have to credit a judge who says, I've thought about this some more, and I think I was wrong. Because not all judges are willing to do that. There are an awful lot of judges out there that say, because I said so, that's my ruling. Take it or leave it. If you don't like it, appeal it. So I always appreciate a judge who is willing to say, you know, I've given this some more thought. I did a little more research, and you might be right. Judge Canoni did that and came back and she didn't change the verdict form, but she did change and added to the instructions relating to the verdict form. Nowhere in any of those instructions did it say any or all charges. And in most verdict forms, the form says, if you find the defendant guilty on any or all of the charges. And that sort of lets the jury know that they can find for one or two or all the charges. So I don't recall the prosecution actually agreeing, but I think that the prosecution accepted that the judge gave that additional direction. Now, as I say, the prosecution was responsible for formulating that verdict form, and they chose that over a more standardized form. So I don't know that they had a lot to stand on when the judge said, you know, you might be right, this might be vague, but I think I can fix it, I can cure it by giving them a better instruction on how to fill out the form. But the instruction wasn't sufficient and they didn't understand it. So, good question. Okay, we've seen that question, so let's pull up the next one. Is it Lori Cox or her lawyers? She does not seem intelligent enough to me to be deciding. Do you think she's just riding, rolling, taking advice at this point? I don't. The reason I say that is because she absolutely would not agree to waive her speedy trial right in her Idaho trial. Even though she got advice somewhere, and there's some speculation, maybe it was her first attorney, Mark Means, maybe it was her father, Barry Cox, who's very anti-government, anti-establishment, but she got some advice that she absolutely would not budge from, and that was that you never, never, never waive your right to a speedy trial. And so she has stuck to that even after her court-appointed attorneys, Jim Archibald and John Thomas, said to her, we need more time, we need more investigation, we need to formulate the plan. There were things that she absolutely was not going to agree to. And the important thing to remember is that there are things that only the defendant can decide. One of them is waiving your speedy trial. That is a decision that is solely up to the defendant. The other one is whether or not the defendant is going to testify at trial. So it really isn't a matter of the lawyers deciding for her. She has the absolute right to decide whether or not to waive her speedy trial. She did not. The judge continued the case over her objection, which I think is really interesting. And I really want to know how the judge justified that. It's got to be under Arizona law. So that's something I would like to delve into deeper when I get a minute. So what I want to say is, while we're pulling up the next question, I have got this little bubble here looking pretty decent, but y'all don't want to see what is outside of this bubble when it comes to the organization of my office or anywhere else in my house, because right now it looks like a bomb went off everywhere. And I have pictures and stuff stacked everywhere. Hopefully sometime in the next 2 or 3 weeks, I'll figure out where to hang pictures. But you can see there are some patch spots on the walls around here that, so there are some rooms that need to be painted and some work that needs to be done before I can even get to the thought of hanging pictures. So yeah, moving is a work in progress. Hi, Roz Ott. If Karen Reed gets a retrial, will Proctor be allowed to be a witness? His track record suggests that he should not be called, as his bias, attitude, and possible evidence tampering are problematic, highly problematic. And so here is the question. The question is whether the prosecution can keep him off the stand if the defense calls him. Because I got to tell you, I am absolutely sure that the defense will call him, and they will ask to treat him as a hostile witness, and they will go after him and really take apart the investigation and the shoddiness of the investigation and his attitudes, bias, potential evidence tampering. So I do not believe that the prosecution will call him, and he's kind of radioactive at this point. The bigger question is whether they can do anything to keep him off the stand if the defense calls him. And I can't imagine the defense won't call him. I don't recall. We heard that an awful lot in the Karen Reed case, didn't we? We heard it a bit in the Baldwin case too. Is it rare for a judge to not allow attorneys to give a basis for their objections? That seems like a problematic practice. I absolutely agree. So here's the dilemma, and you saw it in the Baldwin case. Carrie Morrissey was notorious for this in Hannah Gutierrez Reed. Her speaking objections, which were essentially testifying. So typically, when you make an objection, you say, objection hearsay, objection calls for facts not in evidence, objection relevance, objection, and you state the basis for the objection. And that's all you state. Where it gets tricky is when you have lawyers who don't have any discipline and who promptly then verbally vomit all of their reasons for the objection. And essentially what they're doing is they're testifying and getting evidence in through testimony. They're getting evidence in through objections that they're not able to get in through testimony. And it's a sneaky kind of dirty way to do things. And Carrie Morrissey was pretty notorious for doing that during Hannah's trial. And that was one of the reasons why the defense filed motions initially and said, rein her in, judge, because she is out of order. And I think that is the reason why Judge Cannoni said, all I want to hear from you is objection. I don't want to hear speaking objections. I don't want to hear justification. If you have to talk to me about the basis for an objection, approach. And so there were instances where one or the other would object and she'd say approach. That's because she didn't understand what the basis of the objection was. Here's the issue, though. If the issue is whether or not those sidebars were on the record, because if the appellate court can't tell what the basis of the objection was, then you run the risk of not having made an appellate record from which those orders can be appealed, because you can't appeal something that wasn't raised at the trial court level. So, for example, very few lawyers will raise ineffective assistance of counsel when they're the trial lawyer. And so it's against their interest to do that. But it's very difficult to bring that as an appellate issue if it's not raised at the trial court level. So, sticky. So I agree that Judge Cannoni would have done better allowing them to make, one word or one title objections. Objection presumes facts not in evidence. Objection hearsay. Objection relevance. Kind of those standard kinds of objections that you hear in every trial. So I don't know what that's going to look like. And of course, at this point, she's declared a mistrial. So if Karen Reed is retried, that will be a whole new appellate record. So at this point, it's kind of no harm, no foul, but I wouldn't like it. And I don't think that the attorneys liked it at all. But the judge runs the courtroom. So good questions, good in-depth legal questions. Defense attorneys absolutely always get a transcript of the grand jury hearing in their client's case. Grand jury proceedings are secret, and there is no role for a defense attorney. However, if a defense attorney knows that the grand jury is meeting about their client, see, often what happens is you don't even know your client's been charged because there's no indictment until it comes out of the grand jury. But if you have some notice that your client is being looked at by the grand jury, a defense attorney has a right to be present. They don't have a right to speak, and they don't have a role within the grand jury. They can sit there like a potted plant, but they can't object, and they don't have a role in the process. So a lot of times defense attorneys don't attend because of that. And like I say, a lot of times you don't know until the indictment comes out of the grand jury that your client's even been charged. So usually the first opportunity that a defense attorney has to appear on behalf of their client is when they're arraigned on the indictment. So good questions, but they do get a transcript. They also often get the actual recordings, because transcripts cannot always convey the emotions or the demeanor of the person the way that a recording can. So usually they get the recorded interviews and a transcript. And sometimes those can take a long time to produce. Interesting. In grandparents, ballerina's mother. Okay. I think you're talking, the Black Swan murder that's going on right now. She was very enmeshed with her mother. But I don't know. I mean, I guess I have to watch the trial more, but I don't know that her mother was involved in her life, her divorce, those sort of things. But I don't, Ballerina Case, she may have premeditated implicating her own mother watching her daughter while the murder occurred. Well, that might be, but then, they still would have to prove that the grandmother was in on the scheme and knew what the daughter was going to do. It wasn't just, hey, can you watch the kid while I go run an errand, or any of those things. So I don't know enough about that case yet. So I'm going to have to focus in on it a little bit more. There isn't, at least that I know of yet, a suggestion that the grandmother was involved in wanting the other parent murdered so that she could have access to the grandchild. What I've heard about the case so far is that they were married, she became pregnant, and during the time that she was pregnant, she left him and went to live with her mother, and lived with her mother when her baby was born. But I don't know that there was a lot of undue influence or like coercive control on the part of the grandmother. And I think that is the key to the cases that I'm sort of interested in, is that coercive control sort of element. So, but I will look at that one because it may very well be that the grandmother was more interested and more, in the cases that I'm interested in, it's where the grandmother feels like they're more qualified to raise the grandchild than the parents, and are willing to commit murder to be able to raise their grandchildren. So interesting. Hi, Tiff. In the HGR trial, Hannah Gutierrez Reed, the same judge made both attorneys come to sidebar every time they objected. Yeah. And I understand that. And I understand that it really messes with the flow of a trial. It messes with the flow for the jury. It messes with the way that the attorneys present the case. It messes with the overall big picture on the case. But I do understand from the court's perspective, do you want a lawyer, you want to run the risk of a lawyer like Carrie Morrissey making those speaking objections? And the reason the judge required them to approach for every objection was because Carrie Morrissey was doing those speaking objections that the judge felt were attempts to influence the jury. So that was the reason why. I know it is annoying, and I know it just stops the flow. Believe me, the lawyers don't like it any better because you have a way that you want to present your part of the case, and you're in a rhythm. You've got a sort of a tempo that you're working with as you're questioning a witness, and you get sort of into the tempo, and then objection, and then you got to go to the sidebar, and it's so distracting, and then you have to go back and try and find your place, and it's hard. I mean, I don't think you'll find any lawyer who likes it, but when I mean, as a defense attorney, I think that you would prefer that to having a prosecutor who's basically prosecuting their case through their objections too, because you don't want that happening. And there are prosecutors who really push that line, and Carrie Morrissey was one of them. If you watch the very beginning of Hannah's trial, they were doing regular speaking, regular objections on the record, and it didn't go well. And the defense complained vehemently about it. And the judge's solution was to require them to come to the sidebar every time an objection was made. And it's kind of like the lesser of two evils. So, I mean, ideally, Carrie Morrissey should have behaved herself, but she didn't. Regarding Karen Reed, I also thought perhaps the choices didn't include a choice of not guilty. I would have to go back and look at the verdict form. I believe that there was a choice for not guilty, but below that then were the lesser included, did it happen this way? Did it happen that way? Did it happen this way? That you had to check one of those. And I think that was very confusing for the jury, because the jury was like, okay, if she's not guilty, then do we have to go back and say she's not guilty of doing it this way or doing it that way? I mean, the form was really not clear. And so I think that the jury was reasonably and truly confused. And my experience, my new office has this wonderful window right here. And as the sun starts to go down, the lighting changes. So I've been trying to compensate with a ring light on this side, but the ring light, as the sun goes down, then the ring light gets too bright. So I'm going to keep working on the lighting. Anyway, yeah, I think, oh, go ahead. Shelley's Flowers. Do you notice that often grandparents assert control over parenting? As a speech therapist working in pediatrics, even when they are without crimes, I feel like it hurts the development. Thoughts? Yeah. Now, in addition to criminal law, I did family law, divorce and child custody. And I also did, the last 5 years of my practice, I did primarily child welfare cases. So I dealt with a lot of grandparents. And, often what happens in child welfare cases is that Child Protective Services comes in and they say, we need to place the child with a grandparent. That's how Kay and Larry Woodcock ended up with JJ. And we want to place the child with a family member, and the child gets placed with the grandparents because the parents are unable to provide a safe and stable home. But it also plays into, in some cases, grandparents thinking my child and their partner are not competent parents, and this child isn't safe with them, and I know best, and so I'd be better to raise the child. Well, what a lot of people don't understand is that the question is never who would be the better parent. The question is always, can we return the child to parents who meet minimum adequate standards? Because the preference is always for the parent of the child, at least one, if not both, of the parents of the child. So in a child welfare case, child welfare can't say, I know the grandparents could give this child a much better life and they have more money, and it's the same if they're not relative foster parents. Child welfare can't say the kid's going to have a better life if they stay in this foster placement. What they have to ask is whether or not the parents have reached minimum adequate standards for health and safety to allow the return of the child. And they cannot look at what the alternatives to that return might be. I know sometimes that sounds a little crazy, but I agree that there are grandparents who are supportive and defer parenting to the parents and are reasonable, helpful, loving grandparents. And there are grandparents who believe that they know best and that they could do much better taking care of their grandchildren than their own child and that child's partner. And I think that when you get those kind of grandparents who are intervening in the actual decision making about child rearing, I think it is confusing to children, and I think that it is I think that it is developmentally harmful. So these are good points. And, I think that is what interests me about these cases. Y'all know me by now. You know that I'm interested in stories that have something else, whether it's doomsday beliefs and Lori and Chad's relation to the LDS Church and their mental health and all of that, or whether it is this sort of undercurrent of toxic grandparenthood. That's what makes a case interesting enough for me to want to write about it and to spend months steeped in the subject. So it's definitely something that is on my radar. And I'm hoping that within the next few months, I will be putting together a book proposal and talking to my agent and my current publisher about their interest. So thanks for that. Hi, Jane Blackbird. If you wait long enough to unpack every box, opening is like Christmas. Well, it is true. And what I'll say is when we moved from Arizona to Idaho, we knew that our time in Idaho was not going to be our permanent resting place. So we never unwrapped a picture, hung pictures on the wall, and we never really got out of boxes a lot of the stuff that we didn't need right away. So in a lot of ways, it was kind of like Christmas. I opened up some kitchen boxes and was like, oh, I forgot I had that. Because, you know, I love kitchen gadgets. And if there's something I am absolutely a sucker for, it is books, quilting gadgets, and kitchen gadgets. So it's kind of like the female equivalent of guys in a hardware store or tools. So yes, I have a lot. And I actually haven't seen my actual Christmas stuff for a couple years because we went to celebrate Christmas with my daughter and my son-in-law's family down in California. And so we didn't get out a lot of Christmas. So, but Christmas is in Bend this year for the whole family. So we're really excited about that. What else you got for me? Last call for questions. Don't forget, if you have cases you would like me to follow, or you are interested in having me perhaps come and do a book signing in your community, drop those things in the chat, in the comments, or in my email and let me know. Because I'm very interested in what it is you all want to talk about. And I love to get around and meet as many people as possible. Don't forget, CRIMECON 2025 is in September, early September of 2025 in Denver, Colorado. And it gets bigger every year, so I don't think it'll disappoint. I've heard varying responses from people who volunteered. I heard from several people that it was a great way to get involved and a great way to get a free ticket to the entire conference. I also heard people say it was exhausting. I was on my feet, and it was a lot. So, I know that they try really hard to give the volunteers, if you work one day, you come for the rest. I mean, I know that they try and get make people available to take advantage of the conference. So, but you can keep that in mind. I'm sure that there's a lot of standing around. I know there is, and a lot of directing traffic and what room you go to, and but I'm sure there are also lots of opportunities to visit the Creators Row and listen to a lot of the presentations and seminars. So if you're going to be in the Denver area, it's definitely something to keep in mind. I've already made my reservations and I'm planning to go. So anything else? Jane Blackbird. I've already suggested the Larry Milite case in San Diego involving spellcasters. So just putting in another suggestion. I will look at that. There is some suggestion in that case that is started this week. I can't remember the guy's name, where he's schizophrenic and killed his mother, and he was suggesting that she was a witch and she was casting spells on him, and that was why he had to murder her. So if there are no other questions, yes, we are still doing crane quilt squares. Yes, you can still download the pattern off of my Google Drive with the link that's in the show notes. The squares finish to 6 inches. Use a black background and any color fabric that you like for the actual folded crane. One of my things that's on my to-do list this week is to get a P.O. box set up so that I have a mailing address for y'all to send things to. So I hope by next Wednesday we will have an address. So if you have squares, I did get some squares that came in just before I closed the Idaho box. It does have a forward on it. So anything that is sent to that address that may have missed the cutoff will come to me. And I will try my best to get a P.O. box set up so that we can keep those crane squares coming in. I do still have some JJ and Tylee wristbands. We gave out most of them at CrimeCon, but we do have a few left. If anyone would still like them, you can send a self-addressed stamped envelope once we get that new P.O. box set up. So I want to say thanks tonight for everybody being here. Thank you very much for being patient with me with being a little tired and a little off my game and my lights not being set up. And I appreciate you being patient with me with all of that. I want to say thanks to everyone who has pre-ordered the book. Thanks to those who have offered to be part of the book launch team and read it in advance and post reviews. Thank you for all of the really sweet comments and emails that I have received this week about people who are already delving into the book. Thanks for your kind remarks and your support. I really appreciate that. It's very affirming. Writing a book can sometimes be a little bit lonely and a little bit, you just don't know until it goes out into the world how it's going to be received. So it's always so nice to hear from you all as you're reading it and saying, okay, this is good. I like this. So I appreciate everybody who took the time to reach out. And I appreciate everybody who's taking the time to read the book and waiting to post your reviews. I will be sending you a reminder on September 24th to post your reviews, because that is when Amazon will start accepting reviews. The other venues, I don't know about Barnes & Noble, but I do know you can post early on Goodreads. So if you are so inclined, you can post on those in those other platforms. So I want to say thanks so much to Jen, our moderator par excellence. She just does a great job for us. She also administers the Good Lori Facebook group. So if you're not a member there, be sure and sign on there and take a look at the newsletter. And like I say, let me know if you've got cases you want to really deep legal dive in. So with that, I'm going to say good night. Have a great week. And I will see you next week, next Wednesday. Good night, y'all.